Okay. Following on, by considerations, I mean you need to know about things that a plaintiff needs to consider before they initiate a civil claim and to even decide whether they should initiate a civil claim. Fortunately, again, this is a bigger diagram. Some of these have been removed from your study design, so you have to know even less. The ones that have been removed are negotiation options and scope of liability. So the ones you currently need to know are the limitation of actions, enforcement issues, and costs. So I have removed the information about these other two from the slides. This is more like if you want to read up on it if you're interested, but we will only look at limitation of actions, enforcement issues, and costs. So we'll start with costs. It's the easiest and the most self-explanatory. Costs are any related costs that the plaintiff is basically going to have to pay if they want to go to court, initiate a claim. They need to decide whether essentially it's worth it to spend all this money to take the accused person, sorry, to take to initiate a claim against the defendant. So let's see, costs can be really, really high. And the higher the court jurisdiction that the claim has to go to, the higher the level in the court, the higher the cost will be as well. So lawyer costs, 200 to 600 per hour, for example. Solicitors deal with documents, so their barristers are the ones that are lawyers in court, but people need solicitors as well to deal with legal documents. Jury costs, if it's not an automatic right in the civil justice system, but basically one of the parties in the civil justice system can decide that they want a jury, but then if they request it, they actually have to pay for it because it's not an automatic right. Okay. Pleadings, pretrial procedures, paying for the lawyer the whole time, paying for legal advice, etc. Now, what's the biggest consideration when it comes to costs is that even if you're successful as the plaintiff, you prove that the defendant is liable, and you get damages, so you get paid back the money that you were trying to sue the defendant for instance. The judge will give something called an adverse cost order to the losing party. So that would be the defendant, because the defendant was found liable, we said in this example. An adverse cost order for the party that was found to be in the wrong, it makes that party pay money to the other party to try to cover their legal fees. The problem is it doesn't cover all the legal fees. It's usually insufficient. So the plaintiff needs to decide basically if it's worth taking the defendant to court, because there will still be some financial loss for them even if they're successful. And if they're unsuccessful, they will have to pay an adverse cost order to cover the defendant's legal fees because they failed to prove that the defendant was liable, was in fact responsible. So there's tons of considerations when it comes to costs. Now, the limitation of actions is the restriction placed on the time within which a civil action can be commenced. Basically, we have a Limitation of Actions Act in Victoria, Limitation of Actions Amendment Act 2002, the one that you need to know. And it states if you have suffered a certain type of a civil wrong, the minimum amount of time that you can wait before you initiate a claim, or it will be invalid. It cannot go to court. Why do we have that? Obviously, the defendant shouldn't be scared for an infinite amount of time, thinking that what if the plaintiff does decide to take legal action against me at some point 10 years down the line? So we have to set periods of time, and they're different for each type of civil wrong, that states how long the plaintiff can wait before they decide. Okay? It also ensures that evidence stays fresh and accurate by ensuring that no one is waiting too long. So you won't really need to know about the periods, but you'll pick some of them up over time from your textbook, and it is quite interesting to read up on. Extensions are only allowed for certain reasons, such as maybe, maybe you were in a hospital for a really long time and you couldn't physically initiate a claim, for example. So there are only certain circumstances. Um, for defamation, for example, that's where someone says things that are untrue and harmful to our reputation. Defamation can only be initiated within 1 year of the act occurring. Negligence and injury, they're 3 years in the civil justice system. Now, what are enforcement issues that the plaintiff needs to consider before they initiate a claim? These are complications that can occur during the application or execution of a court order. That means all the things that can go wrong, even if we are successful as the plaintiff in proving the liability of the defendant. Ways that we fail to get the money back, ways that we fail to enforce the damages and get the money back. Okay. So some examples would be we need to consider whether the defendant would even be able to afford the damages that the plaintiff is asking for. So even if we prove they're liable, can they pay us the money that we're trying to get? Whether the defendant is even in the country, because if they're not, it might be difficult to enforce damages awarded to the plaintiff. So things like if they're in a different country or if they're in prison might mean they don't have any finances as well, may limit enforceability and make us not want to initiate the claim as the plaintiff.